This is Duke University.
Global trade and environmental justice.
Human rights issues are still.
The term Ubuntu.
The Alien and Sedition Acts.
Is making inferential discovery.
The importance of an archive.
The John Hope Franklin Center.
Good morning. I'm Deborah Weissman, and it is my privilege to introduce this panel on legal issues. As somebody who teaches law and values the structures and the protections that laws provide, I think it's really important that all of us think about how we can claim legal norms, particularly as it relates to this issue of extraordinary rendition and torture, not only as a way to make apparent and transparent the illegal nature of these actions, but also because we have to think about how we get to use the laws to stop it, to gain accountability, and to gain remediation. So I'm going to introduce our panel of legal experts, and I'm going to start with the person who's speaking last, and that's Steve Edelstein. And Steve is the furthest to my right, and Steve is a partner in the law firm of Edelstein and Payne, and he's also the chair of the National Lawyers Guild Working Group on Torture. I'll go through their bios very quickly because you do have that information, but I did want to just point out a few things about our panelists. Next, working backwards again, is Steve Watt, who is the senior staff attorney at the ACLU Human Rights Program. And Steve's been perhaps single-handedly pushing forth in the courts so that we can reclaim some system of checks and balances, and so that what's done in the name of national security and foreign policy complies with constitutional and international laws. Meg Satterthwaite is here from NYU, and she is a professor and the director of the Center on Human Rights and Global Justice. And it's her work that's been in many ways, especially for lawyers and legal scholars and law students, absolutely path-breaking in understanding the illegal nature of extraordinary rendition and torture. The next three speakers I want to introduce I have a particular affinity with because they're my students in the Immigration and Human Rights Policy Clinic, and I'm so pleased to see them here on the panel of experts. And they will be talking about some of the international legal norms that, again, we have to claim and use to stop these acts and to gain accountability and remediation. I also want to point out very briefly that they are working on another project related to this with the assistance of Steve Watt and Gavin Simpson and Steve Edelstein, and that is to really tie in the most specific way this global spider's web that you saw to North Carolina and to some rendition flights that have affected 4 individuals in particular. And then they will be working with NC Stop Torture with that information to go back to Governor Perdue and some of the other North Carolina state officials to present that evidence in a very tight and concise and accurate form. So without further ado, we're going to start with Marianne. You're going to go first. And I didn't say their names. How rude of me. Marianne True. I know them. Marianne True, Taiyabba Qureshi, and Paula Kweskin.
So good morning. On behalf of Taiyabba and Paula and myself, we just want to say how excited we are to be and privileged to be with all of you today. As Professor Weissman introduced, we are students in the Immigration and Human Rights Policy Clinic, and we have spent the last semester working on 2 projects, one examining the international legal norms relevant to extraordinary rendition and torture in North Carolina. And our research will culminate in a policy paper which will be posted on the clinic website in May, so be on the lookout for that. And again, our second project with the assistance of Steve Watt and Gavin Simpson is an affidavit connecting North Carolina aero-based flights, North Carolina-based aero flights to the extraordinary rendition of 4 specific individuals. So our immediate goal for the next 20 minutes, for the 3 of us at least, is to provide an overview of 3 specific international legal norms that are relevant to extraordinary rendition and torture: the International Covenant on Civil and Political Rights, the Convention Against Torture, and the Nuremberg Principles. And we selected these 3 because the United States is a party to the International Covenant and the Convention Against Torture, and thus has freely assumed obligations under those treaties. And then the Nuremberg Principles because the United States was really a leader in its creation, having witnessed the atrocities of World War II. So I will begin with the International Covenant on Civil and Political Rights, or the ICCPR as it is known. This treaty was adopted and ratified by the UN General Assembly in 1966, and it entered into force in 1976. The treaty is monitored by the Human Rights Committee, whose job is to ensure implementation of the provisions by state parties, and also to interpret the ICCPR provisions that are regarding issues of international concern. So currently there are 72 signatories and 165 parties to the treaty, including the United States, who ratified the treaty in 1992. So how does the ICCPR relate to extraordinary rendition? Well, the most relevant article is Article 7, which states that no one shall be subjected to torture or to cruel, inhuman, or degrading treatment or punishment. So clearly there's no specific reference to extraordinary rendition. However, the Human Rights Committee, the monitoring body, has read a non-refoulement obligation into this article. And refoulement is a term that refers to the practice of sending individuals to another state for the purpose of persecution or torture. And this is explicitly prohibited in the Convention Against Torture, which Taiyabba will discuss later. But finding this non-refoulement obligation in the ICCPR is especially significant to the argument against extraordinary rendition, because Article 7 prevents refoulement to not only torture, but also to this broader category of abuse, this cruel, inhuman, and degrading treatment. So the United States argues for several reasons against application of the treaty. First, they say that the ICCPR doesn't apply to the United States because at the time of ratification, it included some reservations and declarations that limited the scope of the treaty. So under treaty law, a state party can include what's known as RUDs, reservations, understandings, and declarations, which are basically conditions to acceptance of a treaty. And states will do this in order to carve an exception for themselves, especially concerning provisions that they might object to. So when the United States ratified the ICCPR, it included a declaration saying that the treaty would be non-self-executing, meaning that the provisions would have no effect on US law unless Congress passed some additional implementing legislation. And to date, the United States has not done so, and so it says treaty doesn't apply. A second argument against application of the treaty that the United States asserts is that it doesn't apply to individuals who are extraordinarily rendered because all of that occurs outside of US territory, and the treaty only applies to individuals within US territory. And they derive this argument from Article 2, which states the treaty applies to all individuals within its territory and subject to its jurisdiction. So despite all these arguments, the ICCPR still applies. First, for several reasons. First, even though the treaty is non-self-executing, Article 2 still has this obligation that state parties take the necessary steps to give effect to the treaty provisions. The United States signed and ratified the treaty, and so they have this obligation. And failing to, say, pass the implementing legislation to give effect to those rights may itself be a violation of the treaty. Second, in regards to this question of territory, the Human Rights Committee has interpreted the territorial jurisdiction question in a broader way than the United States. So instead of looking at whether an individual is physically in US territory, they look at whether an individual is under the direct and personal control of the state in order to satisfy the requirements of ICCPR. So sometimes it's best to understand these arguments through the actual stories of people who have been extraordinarily rendered. And some of these you have heard earlier from earlier panelists, but I think it's always good to kind of keep these stories in the back of our mind. Abu al-Qasim Bertel, for instance, he is an Italian citizen of Moroccan descent. He was traveling in Pakistan on business when he was detained and then eventually transferred to US officials. On May 24th, 2002, Bertel was handcuffed, blindfolded, stripped of his clothes, shackled, and dragged aboard an aero contractor's rendition plane bound for Morocco, where he was then detained, interrogated, and tortured for a period of 8 months. Binya Mohammed, an Ethiopian national living in the UK, was captured in Pakistan and rendered twice, once to Morocco and once to Afghanistan. Kaladell Mastery, a German citizen, was arrested in Macedonia and rendered to Afghanistan. And Bishar al-Rawi, an Iraqi citizen also living in the UK, was arrested in Gambia and then rendered to Afghanistan and then tortured. So as you can see, none of these men, and from the stories that you've heard from Gavin Simpson and Christina Kyler, these people never set foot in U.S. territory. And so the United States point to that fact as not being able to extend the protections of the ICCPR to them. However, when these men were on the rendition plains and in these overseas facilities, they were held captive by U.S. officials. They were controlled by them and unable to, with no means to escape. So this control, under the control test, is sufficient to satisfy the requirements of the ICCPR and give them ICCPR protection. So just to conclude, the monitoring body of this treaty has interpreted provisions to really implicate the U.S. practice of extraordinary rendition. And the United States, in persisting to ignore these interpretations and also to continue arguing that it doesn't apply because of these reservations and declarations, really contradicts obligations that are found within the treaty itself. And again, this is a treaty that the United States has ratified, has signed and ratified. Thank you.
Thanks, Marianne. Good morning, everyone. I'm going to be discussing the Convention Against Torture, or CAT, as we call it. CAT was passed by the UN General Assembly in 1987, and it was signed by President Ronald Reagan on behalf of the United States in 1988. And then the Senate finally ratified it in 1994 with the RUDs, like Marianne mentioned, reservations, understandings, and declarations. CAT is very, very helpful to the objective that we're all trying to achieve. It provides that each state who is a member state must take measures to prevent torture, legislative measures, administrative measures, and judicial measures in any territory under its jurisdiction. And this is an absolute requirement. It's called non-derogable. It's a non-derogable requirement, which means that no exigent circumstances, no theater of war, no political circumstances, nothing can justify torture in any sense. And there's also no chain of command excuse. I was just following orders. Under the Convention Against Torture, that is not an excuse. You can still be responsible. You are still responsible for the torture. And CAT also requires that the states criminalize torture, the attempt to torture, and the conspiracy to torture. So through this talk, as I say torture, I mean all of those things. And also that the state provide appropriate punishments for people who engage in that practice. CAT also requires that the state give itself jurisdiction, which basically means can we prosecute these crimes, over acts occurring in any territory under its jurisdiction. So that can include the 50 United States or territories abroad where the United States exercises control and basically almost owns that piece of land as if it were a state or a territory. To give itself jurisdiction, very relevant to Arrow, when torture occurs on a ship or a plane registered in that country, or when the offender, the person doing the torture, is a national of the United States, of the nation, no matter where the torture actually occurs. So all three of those things are very relevant to North Carolina. The CAT also provides what is called the non-refoulement obligation, which Marianne also mentioned, that requires that no state shall expel, return, or extradite any individual to a country where there is substantial grounds to believe that they will be tortured. And this is kind of the most powerful tool that we can use, both the expansive definition of torture, which includes acquiescence to torture, not just the act of torture itself. And the United States, not all of its RUDs were bad. One of the understandings that the United States took of torture was that not only acquiescence to letting someone else do it on your behalf, that's definitely covered, but also awareness of torture, that a public official has awareness of torture, that it's happening, and does not fulfill that person's legal duty to stop it. Or willful blindness, that you turn a blind eye and ignore that it's happening and you know that it's happening. The Senate also declared that it was non-self-executing, which means nothing can happen until we say it happens. And so 2 laws were passed in the wake of the ratification: the Federal Torture Statute and FARA, Foreign Affairs Reform and Restructuring Act. The Federal Torture Statute gives the United States jurisdiction over these crimes, and it has 2 major provisions. One, that the United States can prosecute this act of torture when the offender is a U.S. national, regardless of where the torture occurs, or if the offender is present in the United States, even if that person is not a citizen. FARA, Foreign Affairs Reform and Restructuring Act, has two parts also. The first part is it declares absolutely as a policy that the United States will not return someone to a country where there is a substantial risk of being tortured. Here's the important part, regardless of whether the person is physically present within the United States. And it also requires that the agencies of the United States pass regulations so that their actions do not violate this policy. So to this day, the Department of Homeland Security, Department of Justice, and Department of State have passed regulations to put themselves in compliance with FARA, but the CIA, the FBI, and Department of Defense have not. The United States uses two main ways to evade responsibility under CAT, and neither of them are very successful or very good. The first is the United States is plain out failing to enforce the laws that it already has passed. The federal torture statute gives jurisdiction and declares that the crime of torture is prosecuted within the United States, but no one has ever been prosecuted using that statute. So it's just not being enforced. That's like saying, there was a murder, but we're not going to enforce it because we just don't want to. Again, FARA also has not been really enforced on the CIA, the FBI, and DOD who haven't passed regulations. The United States also is trying to limit the applicability of CAT by saying that it doesn't apply outside the territory of the United States because extraordinary rendition happens from outside to outside, not from inside the United States to outside the United States. But if you look at FARA, it says that regardless of whether a person is physically present within the United States. So we already have declared that we accept the extraterritoriality, which with the big fancy legal term, extraterritoriality. And Marianne also mentioned the control doctrine, the personal and physical control. You will hear later by teleconference from Bashar al-Rawi, in coordination with the British officials and Gambian officials. He was arrested. 3 days later, Aero Contractor plane came and picked him up and took him off to a black site. So we have control over these people, and we are the United States is the one who's participating in this torture. And North Carolina has a lot of options in this manner. In general, the United States can't evade responsibility just by passing off torture to somebody else. Every understanding, every declaration that it makes with CAT has to be consistent with the object and purpose of CAT, which is, of course, to protect people from torture. And North Carolina can use its legislature, just like the House bill we saw earlier, to affirmatively give itself jurisdiction, give itself the power to investigate, and declare policies that we will not allow corporations based in North Carolina to participate in acts of torture or criminal acts abroad. And so, in conclusion, the United States really took ownership of the process of creating CAT. We were a very active member in drafting the Convention Against Torture. We legitimized it by participating in the drafting and by ratifying it and passing 2 laws to enact it within our territory. But it's just not being accepted, and so really North Carolina has the option to pass regulations that use the objects and purposes of CAT to give us the power to use it ourselves. Thanks.
Good morning. Thank you for the opportunity to speak to you all. I'd like to talk a bit about the Nuremberg Principles because they inform a lot of this debate and they serve as a genesis for a lot of the human rights treaties, statutes, and principles that we've thus discussed and that we'll continue to discuss throughout the rest of the day. So, as many of you know, the Nuremberg trials were a series of trials that were prosecuted against the Axis powers in the shadows of World War II. The U.S. took an incredible leadership role at the time. Justice Robert Jackson actually took a leave from the Supreme Court to serve as the U.S. prosecutor during the trials. And he was the one who selected the term crime against humanity. So we know that the U.S. intended to be bound by the Nuremberg Principles. Nuremberg also marked the first time in history that an international court was established to evaluate war crimes and crimes against humanity. So the principles that come from the Nuremberg trials are a series of 7 principles that have then evolved and we see codified and expanded in various human rights treaties. And I want to focus on one particular principle, principle number 1, which reads as follows. Any person who commits an act which constitutes a crime under international law is responsible therefore and liable to punishment. In addition, the Nuremberg Charter established the legal basis for charging individuals accused of the following acts: war crimes, crimes against humanity, and crimes against the peace. And I won't focus too much today on crimes against the peace, but I do want to draw your attention to war crimes and crimes against humanity. War crimes are violations of the laws and customs of war, including ill treatment of prisoners, which we've heard a lot about today. And crimes against humanity include the murder, extermination, enslavement, deportation, and other inhuman acts committed against any civilian population before or during the war, or persecutions on political, racial, or religious grounds. Now, the Nuremberg Charter also established jurisdiction over leaders, organizers, instigators, and accomplices, and it does not give them a way to escape responsibility under international law, even if they acted pursuant to an order of a government or a superior, as long as there was a moral choice available. And this is commonly known as the Nuremberg defense. And as I've mentioned, the 7 Nuremberg Principles form the basis for various human rights treaties, including, as Marianne mentioned, the International Covenant on Civil and Political Rights, but also the Geneva Convention, the United States Army Field Manual, and it also laid the framework and the basis for several of the ad hoc tribunals that have prosecuted war crimes, just like in Rwanda and the former Yugoslavia. Now, with these new treaties came an evolution of the terms that were originally laid out in Nuremberg. So, for example, the crime against humanity. Originally, crime against humanity was always connected to war crimes. But today we see that a crime against humanity can be something a little bit more. And scholars have written about this extensively, including Hannah Arendt, who wrote a lot about the Holocaust and a lot of the war crimes that occurred in the wake of the Holocaust. Now, crimes against humanity may now occur outside of war, and it not only implicates the individual, but the community from where the individual comes from. And in addition, a crime against humanity implicates the humanness of the person. So we look a little bit beyond just the actual crime that's occurring, but against all of us connected in the community and how we feel as humanity and what it means for us as we stand by and watch this crime taking place. Now, recently, in March, a special report to the UN investigated specifically this secret detention network that Gavin talked to us about earlier today, and recently came out believing that this system of secret detention facilities around the world would likely rise to a crime against humanity. So we've got this really interesting abstract notion and theoretical philosophical idea that we've been thinking and studying ever since the Holocaust and since World War II, but then we also have the UN coming out and saying that they believe that this network of detention facilities could also rise to the level of a crime against humanity. As I mentioned before, the Nuremberg Principles gave greater responsibility to the individual, which led to the rise of the bystander theory. After the Nuremberg trials were tried in Europe, the same type of tribunal moved to the Asian theater for the Tokyo War Crimes Tribunal. And the role of personal responsibility was expanded a little bit more to this definition. Anyone with knowledge of illegal activity and an opportunity to do something about it is a potential criminal under international law unless the person takes affirmative measures to prevent the commission of the crimes. Now, in U.S. courts, it's very interesting because human rights advocates have utilized the bystander principle that emanates from these principles to come up with a couple of defenses that would shield them from criminal liability were they to be indicted for affirmatively working to promote human rights. And there's a great example that happened in the 80s. There was a case called Vermont v. Keller when a group of protesters carried out a sit-in in the offices of Senator Robert Stafford, and they were responding to human rights abuses in Central America. When they were criminally prosecuted and charged, they successfully used the Nuremberg Principles to demonstrate that they had a citizen's duty to act in order to prevent international crimes from taking place, because they had knowledge that such a crime was occurring. Now, other scholars have written, particularly with regard to mass atrocities, that bystanders can be considered part of the problem rather than part of the solution if they don't take an affirmative stance to act, as many of you are doing here today. So you should be congratulated. I've often asked myself the question, would North Carolinians be implicated under the bystander theory? And I think it's very important to remember that the bystander theory in international law is non-prosecutorial. Legal scholars do not believe that bystanders should be criminalized. That's not the concept, that's not the idea. But it is a way of looking to the role of individuals and the part that they play with regards to international law and standing by when human rights abuses are taking place. So we ourselves cannot afford to stand by idly. We need to press our public officials to take steps in conferences such as these and think about the way that our voices can be heard, and to look to when human rights abuses are taking place and to be inspired by these principles. For that reason, we're proposing a commission of inquiry, again, a tribunal that's non-prosecutorial. It's interesting, a well-regarded scholar once wrote that bystanders play a role in the descent of their communities into violence, and they will inform the way their children, friends, and colleagues perceive the past. So I think that we have a great responsibility to think about how future generations will view us and the way that we want our history to be written. So in order to embrace this new collective future, we're requesting of ourselves and of our officials that we embrace this new collective future and we think about a Truth and Reconciliation Committee, such as the one that was established for Greensboro for the civil rights abuses that took place there. And even Senator Leahy has come out and requested such a commission. And we might ask ourselves, why do we need this? And again, we want to think that we're not standing by when human rights abuses are taking place. We believe in the need for record keeping, and we want to encourage ourselves and those around us to hold ourselves accountable and to hold our government officials accountable. So thank you very much, and I'll now turn it over to Meg Satterthwaite.
Good morning. Thank you very much. I also want to extend my thanks to the organizers of this conference. I've been extremely moved this morning. I've actually been on maternity leave, and so coming back to this work, I find myself much more impacted by the sort of descriptions of the program. I have two clients who were actually in the program, who were victims of the program. And so I've heard their personal experiences many, many times. Unfortunately, I've had to ask them to go over it and over it again in order to do things like create affidavits. But somehow this morning, hearing about your work, it was impacting me very much, and I promise to go back and tell my clients about the work you're doing. I think this kind of human-to-human work is what really, really matters right now when we can't count on our government. So with that, I want to tell you that I've been sitting here crossing out most of what I had to say because it's been covered. So I do apologize if I'm somewhat disjuncted. I will try not to be. I want to start with the question that was raised at the last panel, which is what's the definition of extraordinary rendition? I think it's a really important question in relation to both the human rights violations that have already occurred and also the ones that may be occurring now. So the conference defined it as the policy expanded dramatically under the Bush administration of secretly seizing prisoners and disappearing them for incommunicado indefinite detention and interrogation using torture. The definition that I and some others have used is informal or irregular transfer, and so that's transfer outside of some kind of process, often a judicial process or an administrative process, such as deportation or extradition, where the individual is at risk of torture or ill treatment. And so that's the reason that, of course, these the focus on the norms about torture and cruel, inhuman, degrading treatment are incredibly important, because we're talking about moving people outside of a process or through use of irregular process into a place where they're likely to be tortured. However, it's important to keep on the table just plain old irregular transfer, and I'm going to come back to that because that's the kind of thing that we are seeing right now. So we are primarily talking about a particular program that was implemented by the Bush administration, and Gavin Simpson already did a little bit of the historical stuff, so I'll do this very briefly. He mentioned that there were earlier forms of rendition, so just to put those on the table again, there was this concept of rendition to justice. Actually, I will take us back to Reagan, actually before Clinton, which I think is where Gavin Simpson started. So Ronald Reagan authorized this rendition to justice concept, usually bringing people back to the U.S., so kidnapping them abroad and bringing them back to the U.S., putting them on regular trial, giving them lawyers, giving them regular process. And then there was this Clinton-era rendition to justice where people were not being brought back to the U.S., they were being brought to other countries where there was some form of legal process awaiting them. And then we have this form of extraordinary rendition, which the Bush administration put into place. And I'm just going to use regular admissions by the U.S. government to just give you some quick facts. According to the U.S. government, between 98 and 100 people were rendered and detained in the black site program. So that's the one specific kind of black site type of rendition we're talking about, where the CIA actually held them. All of those individuals were subjected to certain forms of interrogation, and the U.S. government says about 30 of them were subjected to these enhanced interrogation techniques. I think we have to look at that with some skepticism, because we do know that a lot of people were subjected to those procedures, and also things that went beyond the authorization. About 50 additional people, or the quote is mid-range two figures, were rendered by the CIA but not placed into the black site program. So these are people like Maher Arar, who were placed into sites abroad and actually in proxy detention and tortured by other countries. The CIA described rendition and delivery in the following terms. During the flight, the detainee is securely shackled and is deprived of sight and sound through the use of blindfolds, earmuffs, and hoods. There is no interaction between the HVD, that's high-value detainee, during this rendition movement, except for periodic discrete assessments by the onboard medical officer. Upon arrival at the destination, the HVD is moved to the black site under the same conditions, using appropriate security procedures. So I just wanted to give a quote, because I think it really is this attempt to sanitize the very horrific experience that individuals experience that has already been described. In the reception at the black site phase, which is what they call it, that's where you have this, again, you've already heard about them getting forcibly undressed and placed in the diaper, et cetera. So this whole process kind of happens in reverse. Once they get to the black site, the clothes are taken off. Again, they have this invasive body cavity search, which is akin to, well, it is in fact a sexual assault, and it's certainly experienced that way by people who have experienced it. And then they're also photographed naked, et cetera. So I just wanted to kind of put that back on the table, because this is a program that was highly codified. It was a program that was very carefully designed to create disorientation, and it was also authorized, which I'll come back to. Okay, so then Obama-era rendition, which I will also come back to. What we know is that Obama, through a series of executive orders, did get rid of CIA black sites, so he ordered that they be discontinued. He also ordered the creation of a task force that would look into how to ensure that the U.S. was actually upholding its international obligations that have already been described regarding non-refoulement. However, the task force came back and essentially said, what we want to do is improve our use of these things called diplomatic assurances. And those are these promises that other countries give to the U.S. that they won't torture this one particular individual. In other words, we know that you normally torture, but please promise in this one instance you won't torture this one guy. You can see how extremely how much I believe those are very effective. So there has been some recommendation that process be improved, but there was not a recommendation that informal transfer more generally be ceased. So I will come back to that. In other words, rendition is still a U.S. policy, even if the extraordinary form in the sense of sending them to these black sites is not. Okay, so the next thing I want to talk about is international law, which mostly has been covered. I'll just point out a couple of things. I thought it was great, the discussion of extraterritoriality. One of the other things the Bush administration said, and I think it's important to bring up here because Obama is continuing it, but not in the same way, was the argument that we're at war. We're at war with this nebulous terrorist group, and because of that, they said international human rights law is totally irrelevant. This is a completely incorrect interpretation of international law. Normally, you would see the two regimes as applying complementarily, and in fact, that is the received wisdom about the way the two norms apply. In addition, you have international humanitarian law norms that would already prohibit extraordinary rendition through Common Article 3, which bans torture and cruel treatment, and has also been interpreted to also include a non-refoulement obligation. So you can't transfer people, you can't torture them, and you can't transfer them to torture either. So it's irrelevant whether we're within a war or not. And then also, I think Gavin Simpson referred to this briefly, international aviation law, which is not a regime of law aimed at protecting individuals, but it is something to note because the U.S. use of these quote-unquote civilian planes was a direct violation of international aviation law, and particular things that aero contractors did can also be understood as a direct violation. Filing dummy flight plans, for example. You can't do that. It's meant to be, you're meant to actually safeguard air traffic, etc. So that's not as interesting because it doesn't directly provide protection, but it may be something that would be interesting to explore. Okay, just one final thing is the prohibition on disappearances. Folks are probably familiar with this from the dirty wars in Latin America, where people were infamously hijacked, placed in secret detention centers, and then tortured and often killed. The law that came out of that was a set of laws interpreting treaties that we've already talked about, the Convention Against Torture, the International Covenant on Civil and Political Rights, and also the Geneva Conventions, saying that is unlawful. It's unlawful to detain someone, to then hide where they are or not acknowledge it, and thereby take them outside of the protection of the law, because everyone has a right to recognition before the law and protection before the law. So we're also talking about disappearances here. This was a mass program of enforced disappearances. Okay, most of the national law I was going to cover has also been discussed. A couple of things to just note. I think it was great to emphasize that we need to call on DOD and CIA to implement the FARA, which has been a requirement that it's had for a very long time now, but it has not implemented. And then I know that Stephen Watt is going to be talking about civil liability, so I also won't go into that. So what actions are required under international law? A lot of this has been covered as well. But I think the key point here is a wide range of very affirmative measures are required to prevent. So we talked about prevention a little bit. I'll come back to that in relation to the current policy. But in terms of prevention, we've talked about criminalization. Of course, after you criminalize, you have to investigate. And that means whenever you have a prima facie case that torture has been used, you have to actually take steps to ensure that you are then going to punish anyone who's responsible for it. And typical things that countries have been requested to do, comparing flight plans of aircraft with dates, locations contained in narratives of people who have been extraordinarily rendered. So the kinds of things that Gavin Simpson and the Council of Europe did, states should be doing that as well. Hey, if these guys were being flown around, let's see which flights they were on, and then let's trace back and see who is responsible. It's not a secret anymore. This work has been done in part by you all. So we've gotten beyond this step. Now it's time for state actors to actually act on that information. You then, of course, have to prosecute, and as the earlier speakers talked about, we have plenty of jurisdiction available to prosecute individuals. And then, of course, once the facts and law demonstrate that someone has committed a conspiracy, aiding and abetting or torture itself, then you've got to punish someone. And of course, finally, you have rights of the victims to redress, extremely important and often forgotten. So how does federal law apply to North Carolina?
We've talked about the relevant actors here: CIA contractors, personnel who pilot or service those flights, CIA front companies themselves in all of their forms, North Carolina state actors and local officials who had information but haven't acted. Unfortunately, we can't look to FARA to directly hold people responsible in court because of the way it was worded. There were a number of judges who tried to actually find a cause of action, but mostly those have failed. Anti-torture criminal statute, of course, applies, and we've already explored the jurisdiction, the facts behind that. There's plenty that could be done under that torture statute. In particular, here in North Carolina, I think the conspiracy and aiding abetting case is very, very strong. And has already been mentioned, willful blindness can help you establish guilt, and we also have this example of people actually directly participating in the torture and cruel and human degrading treatment. The FBI agent, in a leaked document, wrote a memo to his supervisors saying, during the program, saying, hey, we have to make sure we're not involved in this. The US government is actually committing conspiracy to torture. So this is not just a concept that crazy human rights activists have come up with. This is something that US government officials themselves have been concerned about. And that goes to, of course, the DOJ and OLC legal support for this program. Now, what does that legal support do to these potential legal cases or legal actions? The answer is actually not entirely known. And why is that? Because we haven't seen our officials taking action. We know that Attorney General Holder has initiated an investigation. That's ongoing. We know that these enhanced techniques were explicitly approved by DOJ, but we also have evidence that they were used, some of them at least were used before that authorization. And in fact, that one or two individuals may have been used as test cases, which is explicitly prohibited under international law. You cannot use people to experiment, and that is directly because of what the Nazis did in their so-called medical experiments. Rendition techniques are included, as I quoted earlier, in the memos. OLC approval, however, has to be relied upon reasonably. You can't simply rely on something that you know is unlawful. So the question is, if applied, how would it work out? And we just don't know because it hasn't been tried. Also, the DOJ has provided something they call declination letters in certain instances to CIA personnel who carried out techniques under the OLC guidelines. In other words, they told people in advance, don't worry, we're not going to prosecute you. That also means that these people were worried about being prosecuted, which I think is very significant in terms of the level of culpability. A CIA special review concluded there was a series of interrogations in which CIA personnel went beyond the approved techniques, so they've themselves found that to be true. So finally, what really matters is not actually the legal discussion right now, because the legal discussion has been closed for a couple of years in the sense that we know that these things were unlawful under international and domestic law. So what really matters is the political pressure that we can bring to bear. And that's why I'm very hopeful that activists like you at the local and state level can really bring that kind of pressure to demand investigations, prosecutions, and a commission, as has already been mentioned. Let me just mention in terms of the prevention prong. I think I have like 2 minutes. Okay, great. So I just want to tell you about this concept of informal transfer in terms of preventing. We don't only want to prevent transfer to black sites. If we don't have black sites anymore, what are we doing instead? What we know is the US government is moving people without process to other countries where they may either face prosecution under laws of the local jurisdiction, or they may be held for interrogation. And there's a lot of people trying to do investigation to figure out what, the sort of same kind of picture that Gavin Simpson showed earlier. What's important is to talk very clearly about what needs to be prohibited going forward. So I'm going to set out what I am advocating as kind of a baseline standard for any transfer that the US government or any other government is going to undertake. First, there is two threshold principles. Formal procedures for transfer, like extradition or deportation, that are available can't be intentionally bypassed, which we've seen time and again by the US government. They have to pursue those procedures, and if they don't think they're sufficient, they should go and conclude additional extradition treaties. They should use diplomatic processes to improve those processes. Second, the transferring state has to have a valid legal basis for apprehending the person. So you can't simply just go in and grab someone up because you think he's a bad guy. You have to actually have evidence that would support a basis for apprehension under international law. And then, and this is what we've been focusing on, you cannot transfer people to a risk of torture, cruel, inhuman, or degrading treatment. You cannot transfer them to a risk of persecution, which is familiar from refugee law. You cannot transfer them to a risk of enforced disappearance. You cannot transfer them to a risk of arbitrary deprivation of life. And finally, if you are acting in the context of an armed conflict, there are going to be additional protections that will apply. Certain people can't be moved outside of countries, period. Then, and I think this is the part that's harder because we haven't seen any action from the Obama administration on this, procedural guarantees for anyone who's moving. So let's say there's not an extradition treaty, you do have a good basis to pick someone up, and you're saying, you're the CIA, we truly don't want to transfer this person to a risk of all those things I just mentioned. How do we know that? How do we know that the person is not at risk? Well, we have to give that person a procedure whereby they can personally say, I'm really afraid of going to Syria because, I left Syria when I was 16 and the country thinks I'm against the government, for example. So you need to actually have that person involved in articulating their fear and articulating the basis. And they have to have a challenge on that basis before an independent decision maker. And they have to be able to, that person who's making the decision about whether there's a real risk or not has to be able to halt the transfer during the pendency of that. And finally, on diplomatic assurances, I'm looking over at Julia Hall because I'm hoping she's going to talk about this later. A little bit? Okay, good. She's the queen of diplomatic assurances, which is very, very true. So any questions should go to her. Diplomatic assurances have very particular they have very particular guarantees that have to be accompanied. So, for example, you cannot use diplomatic assurance to obviate a risk of torture with a country that systematically uses torture. It's simply obvious that it will not work. If you are going to try to use them, you have to make sure that that independent decision maker I mentioned is a judge, because a judge only will have the capacity to really determine whether these are something we can rely on or not. And then if you're going to use them and a judge has found them to be okay, you've got to have effective post-return monitoring, and that is an extremely high standard that we've seen no government reach, I think I can fairly say. So finally, I just want to close again by saying that I hope that it's extremely clear that the norms that were violated by setting up this program and conducting the program are of the highest order. That's already been mentioned. They're Kogan's norms, and there's no question of their unlawful nature. Absolutely no question at this point. So the only question left is, what are we going to do to stop, make sure it doesn't happen again, and to ensure there's some form of truth-telling and redress for the future. Thank you.
So we're still on morning, so good morning. Let me begin by thanking Robin, Christina, and Deborah for organising today's very timely conference and extending me an invite. And I think North Carolina has come a long way since I received my first invite down here by Peggy Misch from Stop Torture Now Coalition and the ACLU affiliate. And they asked me to talk, I think it was in 2004, wasn't it, Peggy? Or was it before then? It's around then. So it's a long time. And you guys, Stop Torture Now Coalition, have come a really long way since then. I think, in my view, you're one of the most innovative, creative, and effective grassroots groups working on the issue of torture in this country. It's been a real pleasure working with you, and you really are an inspiration for me in my work. So thank you. So let me begin my remarks. There has, in this country to date, been no comprehensive criminal investigation or congressional inquiry into the extraordinary rendition program. Now, in the absence of such accountability mechanisms, US advocates, such as myself, have sought to hold the US accountable by having resort to the federal courts. to seek redress for survivors of the Extraordinary Rendition Programme, and through that process seek some measure of accountability for US officials' involvement in forced disappearance and torture. So what I'd like to talk to today is about the outcome of this approach using the federal courts. Describe some of the case histories for you. Some of you will be familiar with them. And to discuss why, despite the many obstacles that we face in the federal courts, why pursuing that particular measure of accountability has proven a worthwhile endeavour. But what I'd like you to take from this today is that pursuing these cases through the federal courts is not the silver bullet for accountability. It's one measure we should look to, but what we really need is a comprehensive accountability mechanism. And I think the state of North Carolina and you guys can build in towards that accountability mechanism. We cannot rely on the courts to do it for us. We must rely on other measures. So let's turn to the litigation. So since 2004, there's 3 major lawsuits challenging the Bush administration's Extraordinary Rendition Program have been filed in US courts. And in all 3 of them, the US government sought and it obtained immediate dismissal of all the claims on grounds that are wholly unrelated to the legal and factual merits of the cases. So what the courts have said is, even if there is a policy of extraordinary rendition in operation, even if US officials and others have been involved in the extraordinary rendition of these men who are seeking redress before this court, there is no remedy before this court. Now, there are appeals from 2 of these cases pending, but it's far from certain that any of the plaintiffs in those lawsuits, and they're victims of state-sponsored kidnapping, arbitrary detention and torture, that they'll ever be granted their actual day in court. Now, this is a pretty dismal judicial record, I think you'll appreciate. But for us, US lawyers, it wasn't surprising. We knew going into these cases that we were going to face significant legal impediments to getting redress for our clients. And just so that you're all aware, there's only a single lawsuit filed by survivors of US torture policies that has survived a motion to dismiss in this country. And even that suit has been held up on appeal, and it may never actually reach trial. That's the situation here in the courts. So nearly 9 years after the Bush administration's decision to bypass existing legal mechanisms in favor of detention without charge, and interrogation without legal constraint, it remains the case that US courts, while they're prepared to adjudicate torture claims against foreign dictators, they're not prepared to do the same against US officials or contractors. Now, has this litigation been useless? Or worse still, has it been counterproductive in this effort to rein in grave human rights abuses perpetrated by US officials? I would argue that it hasn't been, and that the voices of the survivors of the Extraordinary Rendition Program, amplified through this high-profile litigation, has played a critical role in transforming the public debate here in the United States about human rights in the war on terror, and ultimately in setting the United States on a different course, one not involving the worst excesses of the Bush administration's Extraordinary Rendition Program. So let me take you through the 3 cases that I mentioned and show you how the federal courts have dealt with these claims of forced disappearance and torture in the context of the Extraordinary Rendition Program. The very first case filed challenging the program was in January 2004, and it was by Canadian citizen Maher Arar. It was filed in the Eastern District of New York in federal court, and it was against then Attorney General Ashcroft and Robert Mueller and other US government officials. And it was seeking to hold them accountable for Maher's rendition and brutal torture in Syria, where he was detained for 1 year without charge. Maher was represented by the Center for Constitutional Rights, and the lawsuit alleged violations of the US Constitution and US statutory prohibitions against torture. Now, importantly, none of those claims have been adjudicated on the merits. And this is because the United States government sought immediate dismissal on national security grounds. And in February of 2006, the judge in the case dismissed it. The judge acceded to the government's contention that irrespective of the validity of Maher's allegations, national security concerns which are at the heart of the case, they were reserved to the political branches, to the President and Congress. And there was therefore no judicial remedy that the court could grant. It would be intruding on the political sphere of government, and that wasn't the role of the courts in the opinion of the judge. The dismissal was upheld by the Court of Appeals, and CCR have recently petitioned the Supreme Court to review that case, and that review process is pending. The second case is the case of Kaladell Mastery against George Tennant and Aero Contractors Limited. And this case was filed, we filed this in December of 2005, and we filed it in the Eastern District of Virginia. The defendants were George Tennant, who was then director of the CIA, and the private aviation corporations, including Aero Contractors. And what Kala did was to seek compensation for his abduction in Macedonia and his rendition to Afghanistan, where he was confined in a CIA prison for some 5 months before being released without charge or acknowledgement. Claims were brought under the Constitution and for violations of customary international law, prohibitions of torture and arbitrary detention. Now, before George Tennant and the aviation corporations were due to respond to our complaint, the government intervened in the case, the CIA specifically, and they sought to invoke what's called the state secrets privilege, which is a common law, an evidentiary common law rule that allows the government to block the disclosure of military secrets in civil lawsuits. Now, instead of invoking this privilege in response to specific items of evidence that were which they considered harmful to national security, in this case what the government did was to assert the privilege over the whole case, to have it dismissed from the very beginning without consideration on the merits. And the judge in the district court ultimately upheld the invocation of the privilege. The Fourth Circuit Court of Appeals in Richmond upheld the dismissal, and in October of 2007 the Supreme Court, without any comment, declined to review the case. So that was the end of the road for Khaled in domestic courts. Undeterred, within 6 months of that failure by the Supreme Court to review the case, we filed a petition before the Inter-American Commission on Human Rights on Khaled's behalf. It's a human rights body based in Washington, D.C., and we alleged violations of international law binding on the United States. The United States government, and now that's the responsibility of the Obama administration, has still not responded to that petition, but it's pending. So that's another avenue for redress for Khaled that has still not been exhausted. Now, the third and final case challenging the rendition program, we filed that one in May of 2007 in the federal courts in California. And this was brought on behalf of 5 survivors of the extraordinary rendition program, including British resident Bishar al-Rawi, who you'll hear from later. This suit was brought against a Boeing subsidiary called Jeppesen Data Plan, and what Jeppesen Data Plan did was provide flight and logistical support services to the aircraft, including N379P and N313P, to kidnap and transport these 5 men to detention and torture in CIA-run facilities overseas or foreign intelligence agencies. So what Jeppesen did effectively was serve as the CIA's travel agent, and it was directly involved in forced disappearance or aided and abetted forced disappearance and torture. all the allegations, as in Kaladell Mastery's case, all those allegations were supported by volumes of publicly available information. So, for example, we had flight records which showed that Jeppesen Data Plan was involved in filing flight plans with relevant flight agencies. We also had a declaration from a former employee of the Jeppesen Data Plan company who said that he sat in meetings where the CEO of the company described how they were involved with the CIA in the so-called torture flights. So pretty convincing evidence of Jeppesen involvement in torture and forced disappearance. But as in Kaladell Mastery's case, once again, before Jeppesen had answered that complaint, put up their defense, the CIA intervened and asked the judge to dismiss the case from the very outset because further litigation of the case would be harmful to US national security interests. The judge at the lowest level, he granted the CIA's motion to dismiss. We appealed to the Ninth Circuit, and we appealed at what we thought then was a pretty opportune moment, because it was on the cusp of the handover from the Bush administration to the Obama administration. It was in February of 2009 that the appeal was going to be heard, so it would be Obama that was in charge then, and he had come to office claiming that he was a government that was going to be more open and transparent, and that had disavowed the use of extraordinary rendition and enhanced interrogation techniques, torture. So we were cautiously optimistic that they may take a less drastic view of the state secrets privilege and perhaps allow this case to proceed in the courts. We were sadly disappointed. Prior to the hearing itself in February, Obama had made a public statement to the effect that his government was going to be forward-looking, not backward. And in line with this stance, Department of Justice lawyers at the hearing embraced the exact same position as the Bush administration lawyers had done previously, arguing that further litigation of the case, consideration of the evidence in the public domain in support of claims of forced disappearance and torture would be prejudicial to US national security interests, and the case should be dismissed immediately. So what the Obama administration was doing was saying, turn a blind eye to that publicly available information and ignore this evidence and accept carte blanche our assessment of harm to national security, they said to the Court of Appeals. Now, fortunately for us, in this case, the Ninth Circuit Court of Appeals rejected that position. And they unanimously reversed the lower court. And they said that the case should proceed. You cannot, this can't be a grant of immunity for the Central Intelligence Agency. And they said that there weren't only issues of national security at stake in this case. There was a role for the court to play in assessing whether this was simply a cover-up, whether it was the US covering up embarrassment or mistake or egregious human rights violations, arbitrary detention, and torture. So the Court of Appeals remanded the case down to the lower court and said, proceed. If the government has any claims to make of its national security interests in this case, it can do so at the appropriate moment. So this was a pretty significant victory for us. Because it carried the potential for the door to be open to torture survivors to litigate their cases before US courts. But it was very short-lived because in June of 2009, the Obama administration lawyers petitioned the full panel of the Ninth Circuit Court of Appeals to rehear the case. And that case was re-argued in December, and a decision is pending. But even if the court stands by its earlier decision, it's highly likely that the Obama administration lawyers will seek review in the US Supreme Court. And it's, again, all but certain that a fully fledged trial in a lawsuit brought by rendition survivors is many, many years away. And even if we get to that position, the court will address only the specific claims before it. In other words, there'll be no comprehensive accountability. It'll be a piecemeal process. So let me end with some general observations on the rendition litigation I've got like 5 minutes. And the part that this litigation has to play in the broader movement for accountability. Now, had litigating these cases to judgment been the only or even the primary goal of the lawyers and the plaintiffs in these lawsuits, then it was an unmitigated disaster. I can say that because I was involved. But it's, because we're over 7 years since Maher Arar first filed claims in the Eastern District of New York. And it remains a distinct possibility that neither he nor any of the other plaintiffs will ever have their day in court. So 7, 9, 10 years later. But for the plaintiffs in these lawsuits, and I've met many of them, they were adamant at the start that the principal aim of their litigation was to highlight the abuses perpetrated against them and to halt the practices of rendition and torture, not to obtain individual redress. And I think by that standard, I think it's fair to say that the litigation has been a qualified success. So how so? Well, largely as a result of this litigation, and you guys, I think, will be as familiar with that as I am, these survivors and their stories are known throughout the world. In the US in particular, the lawsuits have had a dramatic impact on an extraordinary public debate about the legality, the morality, and the efficacy of torture. And it's no accident that Kaladell Mastery and not Khalid Sheikh Mohammed has become the public face of the CIA's extraordinary rendition program. Now, although the practice of extraordinary rendition is deplorable in both instances, by presenting an innocent victim, and there are many others besides Kaladell Mastery and the individuals who are the subject of these other lawsuits, presenting an innocent victim to a frightened public, it proved critical to changing the discussion from one about the rights of terrorists on the one hand to one about the tragic consequences of abandoning the rule of law. So it's a different debate. Then the dismissals of the Mastery and Arar lawsuits, that generated pretty widespread public outrage. There was an opinion piece in the New York Times shortly after the Supreme Court declined to review his case in October of 2007, and it was titled Supreme Disgrace. But that led to calls for reform not only of the US rendition program itself, but also of the procedural rules that barred torture survivors their day in court. So President Obama, on his second full day in office, signed an executive order permanently shuttering the overseas prisons and prohibiting abusive interrogations. And now Obama is still insisting on overbroad secrecy claims, the state secrets privilege for one, in attempts to terminate civil litigation. But members of Congress in both houses have introduced legislation citing the Mastery case to reform the state secrets privilege and to allow torture survivors their day in court. But those are some of the successes, and I say qualified successes. And despite those efforts, I think there is, and I know that there is a need for other mechanisms of accountability, for comprehensive criminal investigation, for congressional inquiry that's not stymied by the executive. And these measures of accountability need to come at the federal and the state level. And that's why I would urge you here in North Carolina to get involved in a movement for accountability at the local level and to build accountability at the local level to meet the federal level, because it will come eventually, many, many years down the line. Thank you.
I can almost say good afternoon. I want to thank a few people. Meg Satterthwaite taught me everything I know about human rights law and extraordinary rendition in an unbelievable article which everybody should read if they get a chance. I really admire Steve Watt because he is doing work that needs to be done so we at least know where we stand. Not only knowledge of extraordinary rendition, but something that needs to be articulated strongly, the ineffectiveness and avoidance of the issue by the judiciary, in my opinion, is an absolute derogation of judicial responsibility. How many people here saw the movie Judgment at Nuremberg? Who was in trial in that case? Who were the defendants? Anybody remember? Judges. That's right. Judges were the defendant in Judgment at Nuremberg. I want to thank a person who hasn't been thanked, who had a lot to do with today, two people actually. One is Josh McIntyre, and the other one is Peggy Mish, who spent tons of time helping to plan this conference, doing much work that had to be done. And I want to thank Deborah Weissman for doing what I think is the most important thing we all have to do, education. She not only educates the public, but she educated students who gave wonderful presentations today. Why am I here? Why am I talking about state and regional responsibility in a national security issue? That's a good question. You know, most people look at me when I mention it and say, that's got nothing to do with the state of North Carolina. That's got nothing to do with Johnson County or Raleigh, North Carolina. And in any decent world, they'd be 100% correct. But we don't live in that decent world. We live in a world where if you listen to Scott Horton, Steve Watt, Professor Satterthwaite, we live in a world where our country may be guilty of crimes against humanity. Our country may be guilty of crimes against humanity. Not a minor thing. So let's look at state law. And I want to do it in a little different manner. I want to do it in what can we do as well as what is. In every community, there's a cultural norm, there's a political norm, there's a legal norm. And you have three circles that overlap to different degrees at different times. There's also a moral norm, but I'm including that under the cultural norm. Well, the legal norm in the state of North Carolina, shockingly, is it's wrong to kidnap. That's a crime. In North Carolina, kidnapping's a crime. Detaining a person against their will is a crime. Hitting him's a crime. So, in a very simplified level, almost simplistic, what is being done violates North Carolina law if there's criminal law, if there's jurisdiction. The North Carolina courts have made it clear there's jurisdiction. If some of the defendants live here, and we are talking about now conspiracy to kidnap, conspiracy to falsely imprison, conspiracy to hit. There's a case called State v. Goldberg. Makes it clear, if any part of a conspiracy is done and planned within the state of North Carolina, even though the final act's committed outside of the state, you can be prosecuted. So we now have, quote, state criminal violations. We now get down to some of the things which Steve Watt referred to in a civil sense and Meg referred to, defenses. And there's been an article that may or may not be passed out here, but there's two defenses that people may talk about in criminal law. One is it's none of the state's business. The federal government under the Constitution gives the president national security powers, and Congress can do things, but a state has no right to act in those areas. When you deal with preemption law, it's 100% clear that you cannot claim preemption when you're committing a crime. There should be an examination. You know, if you ever look at anything, should a court say, as Ms. Christine Gallagher was told in a letter from the state officials, President Bush said we're good guys. Therefore, my opinion as a lawyer is nothing's wrong. That's actually what was said by legal counsel to the governor of North Carolina in a very well thought out legal analysis. No, courts are supposed to take a legal principle and look at something called facts. God forbid if we look at these things called facts. Now, the first thing that's always bothered me is the dichotomy can easily be argued, not conclusively, doesn't exist. There is no bit of reliable evidence right now that says, on the one hand, we got to have this torture program to help national security. Many people have said, Coles wrote a book about it, less free, less secure. You can make probably a much more rational argument along those lines. That not only are we giving up the most basic constitutional rights, but we're also making ourselves less secure. But wait a second, the president said, and that's getting down to what everybody here knows, transparency and accountability. Mr. Horton last night in his speech said that Congress should be doing something, and God, we all believe that one. And we all know that that's going to take an awful lot of praying to get to that point. So what are we left with? We're back to the state. Now, the other thing, the state's secret doctrine. I find it incredible, Steve said it, but I find it incredible the lack of the judicial responsibility in evaluating facts. And I think when you come down to political expedience, the political circle, it's embarrassing. Gods, it's no fun admitting that you admitted crimes against humanity. That those crimes, including some of the most disgusting, outrageous things involving sex, which is a big deal in the US of A, that crime had acts of torture and deprivation that nobody wants to think about. So why are we, and that's what needs to be presented to a court. Why do I think a judicial outcome would be? We all know what the judicial outcome is going to be. You don't have to go to law school. You don't have to be a lawyer to know what would happen right now if you went in front of a judge in the state of North Carolina. But it should be done. It can be done. Well, let's get back to the political and culture. What do people think? People think we need this to be safe. First educational point, screamed at every time, nobody should get away with that one. Well, we got a sergeant who was in Iraq who said that it helped, may have in one time, may have in two times, but you look at a whole range. Is it working? No evidence. What is the political norm? How many people here think a state official is going to come out strongly against torture and say that they want to kick the CIA out of the state of North Carolina? Nobody thinks that. Well, that's what we have to work at. The cultural norm is becoming the single most important thing we have. I watched a document. My wife is in the full frame selection committee and given a presentation this morning on a German film about the attempt to assassinate Mr. Hitler. And the film went over, what do you do when you think it's almost hopeless? What do you do when you think it's almost hopeless? And at our level, at a community level, there's two things you can do basically. You can say, wait till it blows over. I got other things to do, and we all do. I may be the laziest person who's up at the microphone today. And there's a whole bunch of other things I'd rather be doing. Or you can say, do something. And do it right here. And why is it beginning in the local community? Well, because the attempt to work through traditional sources at the present time, while important, is extremely frustrating. And that becomes that key point. That becomes extremely frustrating. So what happened in North Carolina, if you want some specifics just for the anecdotes? Christina went over a whole bunch of them with you, but the sheriffs were going to do nothing. The AG was going to do nothing. The State Bureau of Investigation was going to do nothing. And you're out. There's a state statute which says that if a state governmental agency, administrator, believes that illegal conduct is occurring, that person has an absolute obligation to get the State Bureau of Investigation involved. Global Transpark, kidnapping. Well, either kidnapping's not a crime in North Carolina, and that's not true, or they're not doing what they're supposed to do. Now, nobody's surprised when you say that. That's Johnson County Airport. How many people here want their tax money funding an airport that's utilized to help people committing torture? The answer is nobody. Why don't people talk about their tax money being used for torture? That's another major local thing. Culturally, we're at a point where folks are scared to death because they're told if we don't have concentration camps, this society is never going to make it. And we know that's a lie. So I'll say words which are very impolitic. I was lied to by the President of the United States. Because of those lies, we're in a war, and we have a policy of extraordinary rendition, and we're spending $1 trillion. And that at our level, we can say here, we don't like it. I don't want to waste any more time. Thank you.
I want to thank all of you for your time and your expertise. I'd like to make an observation and a question. It seems to me that there is nothing lacking, significantly lacking, in the structure of laws addressing the issue of torture, rendition, kidnapping. What is lacking is the will of the people to enforce the laws. And that really is what we're up against. I've heard a lot of talk in the past about we need better laws, we need new treaties. I don't think that's going to get us anywhere. So the question is, what do we do when the government refuses to carry out its legally mandated obligations? Now, I do think that there are some laws that require, when a government official refuses to do his or her job, that there are laws to address that. I don't know if those have been tried. Does anybody know about that? Writ of mandamus, I think, something like that.
You should do, Steve.
Okay, I mean,
Your state.
okay. North Carolina has writs of prohibition and writ of mandamus, and it would be the biggest waste of time in people. It has to be an absolute mandatory duty for one. A complexity in terms of state law is how do you gather evidence to present in a court. And they've had a tremendous difficulty doing it at the federal level, but at the state level it becomes a monumental issue. And you get stuck with the chicken and the egg. I honestly believe if people did full investigations and committed the resources and could get the cooperation of the Immigration Department, that we could successfully prosecute criminal cases. After having said that, the investigation's not being done, so they're saying, therefore, you can't do anything. And it is a circular thing, and what that does is gets rid of mandamus and prohibition as an effective legal remedy. The first thing you would hear is, what first-hand evidence do you have right now from what people, and goodbye, you go to sleep.
Yeah, and could I just sort of add to that? You know, you're talking about enforcement through the courts or through the judiciary. I think we have to be a little bit more creative about our enforcement mechanisms and looking elsewhere outside the courts. You know, and the point I was trying to make in my remarks was that the courts are one avenue. But if we are talking about getting a judgment from that court that will be binding on the defendants, so in the Jeppesen or Aero contractors or government officials, I think it's extremely difficult, but we can get enforcement through other avenues. So I think we have to be creative here and look elsewhere. And one, you know, potential would be, you know, as has been forwarded here, a commission of inquiry. And using the laws as your framework, but not necessarily going to before a judge, and having the people decide if the law was violated based upon that framework.
I heard on the Amy Goodman show that President Obama had omitted special forces when he ended black holes prisons and has allowed them for special, that they're still happening, the black hole prisons, just not under the CIA. Is there any confirmation of that?
You want to answer that?
Yeah, I think you heard it from me.
Yes, President.
Actually, so I can give a little bit of elaboration on it. Both the New York Times and the Washington Post have confirmed information that I originally gathered. That is that the Joint Special Operations Command was operating a black site prison just outside, sort of on the perimeter of the Bagram Air Base. So not the Bagram prison itself that everyone knows, a special facility. And in addition to that, two investigative reporters who've been working for The Nation have looked at JSOC's operation of similar, I won't quite call them black sites, but let's say forward operating base filtration centers. I think that's the term they use, but also no Red Cross visitation and pervasive secrecy and classification at 8 other locations in Afghanistan, also forward operating positions And this clearly has been an extremely controversial point inside the Department of Defense. We've gotten absolutely no reporting about that because it's been cloaked under high-level security classifications. But in fact, the Deputy Assistant Secretary of Defense responsible for detainee policy, Phil Carter, resigned, saying he wanted to spend more time with his family, to which I pointed out to him, Phil, you don't have a family, which is true. And I suspect very strongly that that resignation had to do with this issue, the JSOC special facility. So I think, frankly, when we go back and we look at the war on terror and this question of detention policy, the still uncharted area of that history is the JSOC operations. Because, actually, the CIA, let's just be blunt about it, can't keep a secret to save their lives. They leak like a sieve all the time. There's no problem finding people at the agency who are quick to tell you, all the flaws and who did what wrong and so on. Everything leaks. By contrast, JSOC is a really tight ship. Almost nothing gets out. They very, very tightly control it. So that's the black hole in our history of detention policy so far. But one other thing I want to note: remember Camp Nama in Iraq, which was the subject of a Human Rights Watch report where severe abuse went on, and we spent a lot of time trying to figure out what was Camp Nama all about. It really wasn't an official detention camp. Well, it's very clear now in retrospect that this was a JSOC-operated black site, and it's very likely that there are a series of others. And they're still going on. They were not shut down. The president's order is very, very clear. It said it shut down the CIA black sites, and that was not the original draft. The CIA limitation was added in.
I want to thank the panel for educating us on the legal aspects of all of this. I found it very interesting, particularly the issues about international law and how they apply here. I've attended trials of friends and family who have done civil disobedience and protests since 1993, and almost uniformly, whenever anybody mentions international law, the judges dismiss it out of hand. Often before the trial even begins, there are statements issued saying such and such defense will not be allowed. So I'm curious, what is the legal basis for those dismissals, and how does that affect what you've been talking about?
I think that's a really important question. So the question is really under U.S. law, and I don't know if these people are being prosecuted under state law or under federal law, but essentially, the treaties are, of course, supposed to be the law of the land under the Constitution. However, not too long ago, something called the non-self-executing doctrine came in, and that was actually mentioned by one of the presentations. And so, unfortunately, there is a doctrine under which judges basically find that if Congress has placed a non-self-executing doctrine statement upon the ratification, they then feel that they can't implement the treaty. Some judges and some regions have said that's not appropriate, that actually it's the judicial role to look to see if the treaty can be enforced directly. And they have developed a doctrine that allows them to then look at the treaty and see, is this enforceable? However, there is not a history of enforcing human rights treaties within the U.S. through that method. Instead, courts look to whether Congress has implemented the treaty. And the Supreme Court recently has essentially said that that's the right way to go, that if Congress has said something's not self-executing, you've got to look to see if Congress has implemented it. If they have, then you can use that that statute itself, but you can't go directly to the treaty. There's all sorts of problems with that under international law. Just to say, basically, this has already been explained too. If we haven't implemented it, that's itself a violation of international law. First. Secondly, it's irrelevant under international law whether something is done under federal law or state law. All actors of the state, and that means the country, all official actors are bound by international law, and it's the duty of the federal government, in fact, to ensure that state authorities implement international human rights law. So if there's a problem with state actors not implementing it, that's actually a federal problem. And under international law, it's an international violation. So I think that the key summary, without having too many more footnotes on what I just said, is that under international law, it doesn't matter that all of these domestic legal problems arise. We actually do have a duty as a nation to implement our human rights obligations. And so I think that what can we do about it? I think it goes back to what Stephen said. It's not going to the court that's going to really do it here, unfortunately, because there are all of these things that make judges worried to act, et cetera. I think it's really demanding that those moral obligations and legal obligations, but we can also call them moral obligations that we've taken on over the past decades, must be enforced. And so in some instances, that's going to take congressional action, but it's also just going to take basic political pressure.
I'd like to ask to thank all of you for being here to help educate us. Now, I wonder how many media people are here to do the same? Are there any? Okay, and where are you? You work here at Duke, but outside of Duke, do we see and right, but where are the newspapers? Where is the radio?
The Independent had a good article on Scott Horton.
That's good. But they're not mainstream.
Let me just say they were invited.
All right. Well, that's the whole point. We have the Independent, we have the Veterans for Peace, and we have individuals from the universities. But where's the NNO? Where's the radio? Where are the TV? All we have is Amy Goodman, and thank God for her.
The NNO had an article yesterday noting that this conference was taking place.
They've had two articles noting that this conference was taking place, one today and one yesterday, both inside the Triangle and Company section.
Well, I wish they'd have somebody here to report on what we're learning. That's the whole point.
You're right.
More questions? We have time for one more.
What do you think about the argument?
Can't hear it.
Sorry. What do you think about the argument of, like, if North Carolina tried to make a commission for this and the federal government said it was, preempted by Congress's exclusive domain over federal or foreign policy, would that be some sort of a commandeering under the 10th Amendment? Could that defense possibly work?
Is Travis here? My partner, Travis Payne, argued a big preemption case in the United States Supreme Court. I read his brief. It's pretty good, by the way, Travis. He won, too, so that was good. But could it be argued? Yes. Could it be won with the courts we have now? Probably. Should it be won if you had a real judge? No. There's one real basic preemption doctrine, which is that you do not use preemption to cover up criminal conduct. And if this isn't criminal conduct, it violates international law, the federal statute, state law, then I don't know what criminal conduct is. So letting people utilize a preemption doctrine to say you can't do anything is dead. I actually was thinking the other day about just going over this stuff. Watergate. The people who were found eventually guilty at a second grade, I'm talking about the initial burglars, not the up the chain thing, were prosecuted in the equivalent of a state court, the regular D.C. courts. I can just see that happening today. And you're making the Democratic Party the Socialist Party of America. And then you're going on in, and they're going to say, this was a real national security concern. we had information that these folks were talking to these folks who were talking to those folks who gave 16 cents in a pack of bubble gum to somebody who gave money to the terrorist. Therefore, can't do the prosecution, now, which at that level is no big, but that means you never get up the chain. You never go any place. And our law has gone to such a degree down the drain in a real basic way that Watergate today could be legal.
I'd just like to add one point about the preemption discussion. The federal torture statute that I mentioned, just to remind you, is the one that gives jurisdiction over offenders who are U.S. nationals who commit torture abroad. The second part of that statute, 2340B, if anybody wants to look it up, says nothing in this chapter shall be construed as precluding the application of state or local laws on the same subject. So even though this statute's untested, we haven't, this hasn't gotten to court, but, there is precedent, there is room even in the laws that give the federal government jurisdiction for the state itself to give itself jurisdiction. So this is not coming out of thin air. There is room within the federal law for it also.
Produced by Duke University. Online at duke.edu.